Hello, my name is Sarah Sheikh, and we are now going to be talking about the Hot Docs program for DASH, which basically is an online program that we use at the DASH clinics to do the litigants' forms as well as to begin their declaration. The website is on the address right here, and basically what happens is that it's bookmarked on all of the computers at the centers and clinics, and basically you just have to access it and follow the instructions on how to get into the program. And from there, do the interview with the litigant, where you as the volunteer will be populating, filling out the information in the fields, and the litigant will then be just telling you what's going on. Once the forms are completed, once you go through the entire program, you would save it and email it or print it out and bring it to the backup attorney for review. So as you can see on the screen, so this training will mostly be screenshot by screenshot rather than going through the program itself. But each screen that comes up in the program, it has been captured, and you will get a chance to see all of those screens, as well as the notes that I want you to make or the things that I want you to note in each section. In this screen, we have, this is where you would go if you entered the web address, and basically we have the litigants forms. This is the petitioners forms on how to petition for a restraining order. This is the petitioner's declaration on how to get into the second section, which is the declaration of statement of facts of the abuse. Income and expense declaration, which you will never do at a DASH clinic because that is not our priority. Our priority is to get the domestic violence paperwork filled out and the litigant on their way to filing rather than worrying about their financial forms. We have the domestic violence petitioner's dissolution / parentage forms. Once again, you would never fill this out in DASH. The only thing we can do is if someone mentions they want to do their divorce paperwork, or if they want to do their financial paperwork because they're asking for support in the domestic violence restraining order, we can tell them to come back or refer them to self-help for further assistance with that after they file. And finally, we have the domestic violence forms for the restrained person. So if the respondent comes in and they tell you that they were served with a restraining order, and as long as it is a civil restraining order, and as long as they have a copy of it, we can help the respondent respond to the restraining order as well. On this side of the screen, we have the sign up to save your work. And you want to click on the link that says already signed up, log in, because you want to log in, and 2, you want to be able to save as you go along. If you hit the Get Started link on the left side, what's going to happen is that you won't be saving and you won't be able to save. And if the program crashes mid-interview, you will have lost everything that you've worked on for the past, and initially it will take you 3 hours. So for the past hour and a half, 2 hours of work. Not only did you lose everything, you have just wasted the litigant's time because the litigant has spent the morning with you and they've lost everything as well. If you do hit on the Get Started link, what's going to happen is you're going to come to this screen that says Terms of Use, and that means that you have not signed in. So you want to go back, and you're going to, once again, like I said, you're going to sign in, and the sign-in information will be on the computers that you're sitting at, or if not, you can always ask the backup attorney what sign-in you should be using. Once you get into the interview, this is the screen that's going to pop up. The litigant, with a brand new litigant, you're going to be hitting Start Fresh to start a brand new case. But if you have a litigant who's coming back, as you can see, we have saved files. So as long as the litigant remembers what computer they were sitting at, which can then help us figure out what account we were using, we can go back and access a litigant's old files as well. But in this case, we're going to hit Start Fresh, which then means we begin our interview. The questions begin with, what county do you want to file your case in? It's always going to be Los Angeles because we are in Los Angeles County. And the location of the DASH clinic and who the volunteer is. Now, why does that matter? Well, if you're sending paperwork for review to an off-site attorney, by you putting your name down means that we then know who to ask for when we call back. So please, of course, put your name down as well. Once you're done with this screen, at the very bottom, as you can see right here with the pointer, with the arrow pointing at it, that you then get to, I'm sorry, I believe it's cut off, so let me just give me one moment. All right, so as you can see at the very bottom of the screen, the arrow is pointing down to the next button. So once you're done with filling out a certain screen, you can then press next and you'll be able to go to the next screen and the next question. Will you need a Spanish interpreter? Would you need an interpreter for this case? And if the litigant is non-English speaking, the court has to provide an interpreter as stated in the last training. And in this case, we've picked a Spanish interpreter, but there is a drop-down menu where we can pick other languages that often show up, or we also have the other option where we can fill in the blank in terms of what language the litigant speaks. At DASH, we as volunteers have to assist the litigant in their language, and if for some reason on that day we don't have a volunteer available who speaks the language, we also have other options like Language Line and on-call interpreters. So we can never tell a litigant to come back and bring an interpreter with them. We do have to provide them with an interpreter, so always talk to your backup attorney if there is a language issue, language barrier, and we need someone to help us overcome that. What courthouse are you going to file your petition in? A domestic violence restraining order can be filed in any courthouse. That means even if that courthouse does not do family law, but a litigant is there with their domestic violence paperwork, that courthouse will accept the paperwork and at least grant the temporary restraining order due to the emergency of the situation. If they cannot, but what will then happen is that the petitioner will then have to go for their hearing, which will happen in 21 days, to the nearest courthouse to where they live. Or it could be that they would go to a hearing in the courthouse where they might have another family law case filed. For example, if they already have a divorce case open, they will then go to their hearing for the restraining order in wherever that divorce case has been filed. In this situation, you don't have to worry about changing or figuring out what courthouse it'll be. You can just leave it at whatever location you're at, Van Nuys, Pomona, Chatsworth, or Antelope Valley. The court will then figure out where the litigant will have their hearing. Are you or your children receiving CalWORKs? If the petitioner in this process wants to ask for a child support order, it matters to the court if they are getting government aid. So we do want to ask the court, we do want to ask the litigant if they are receiving cash aid, which is what CalWORKs is. CalWORKs is not food stamps. CalWORKs is cash aid, and if they are, we do want to mark off yes. This is one of the most important screens that you're going to come across as you're going through the program. What's going to happen is that the boxes that you mark off in this screen will then decide whether the program will ask you specific questions. One of the most important boxes you can mark off is the "We are parents together of a child or children under 18 years old," and that's why there's a big blue arrow there. If you do not mark off this box, you will not get any of the questions regarding child custody and child visitation, which means if you forget that, you are going to then have to do those forms by hand, and that can get very complicated. So if the petitioner who's here has minor, which is very important, minor children with the restrained person, we want to mark off this box. And the screen instructs you that you must check off all that apply, which means if they're also married, mark that off. If they also live together, mark that off. So you want to mark off all of the relationships that apply in this situation. Then it says your first name, your middle name, your last name, which means the litigant, the petitioner's first name, middle name, and last name. And we do have to pick the gender because that ends up mattering when the program fills out the forms for the child custody and the child visitation. So please don't forget to pick the gender of the petitioner as well. The next screen then provides an address. Now this address and telephone number is for the petitioner. One thing you want to point out to the petitioner when you're having them answer your questions is that anything they say and anything we put down will be seen by the other party. That means if the other party does not know the phone number, don't put down the phone number. If the other party does not know where the petitioner lives, do not put down that address. What you can do is you can put down a mailing address, because the court may or may not sometimes send off mail to that mailing address. What they can do, and what is required for Van Nuys, is that they do have to provide a mailing address. So they can put down any address as long as they put down something that the other party already knows. Now, what I just stated about providing a mailing address is only applicable to Van Nuys. Other courthouses allow the litigant to mark off the box that says, I want my address kept confidential, which means in the address space on all of the forms, it will say confidential. That just means that the court will not be able to send any mail to the petitioner and that the respondent will not be able to send a response to the petitioner as well. But safety trumps everything else. So if the litigant does not want to provide their address, we are not going to force them. And unless they're filing in Van Nuys, at Van Nuys we might have to have them provide some sort of mailing address, but that is it. Now, this is a section for protecting other family members or household members. And anyone that the petitioner wants protected has to be listed in this section other than the children they have with the restrained person. And by that I mean other than the minor children who are under 18 that they have with the restrained person. So in this section, we would have siblings, we would have roommates, we would have parents, we would have adult children. The only people that would not be on this section are the minor children, 17 and younger, that the petitioner has with the restrained person. If you make an error on this part and you list the minor children here, and then in the section that they are specifically supposed to be listed in, then the children will show up twice on every single section that they're supposed to show up in, and you're going to have to go through and wipe that out. So be very careful about who you list here. This section, it says protect other family and household members, and the program even tells you other than your children under age 18 with a restrained person. Now, questions about the restrained person you want protection from: full name, any AKAs, gender, of course, and then it goes on to ask you about any other cases, including divorce. A physical description of the restrained person. It asks for the birth date, the race, the height, weight, hair color, and eye color. And the program actually calculates out the date for the age for you. So if the litigant tells you this is the date of birth for X individual, and then the program tells you the individual is 37 years old, you do want to double check and make sure and ask the petitioner, is the other party 37 years old? Because it might be that we have to then readjust the year if the other party is younger or older than that age. If the petitioner tells you, I don't know what their date of birth is, but I do know they're this old, we can help them calculate out a date. And you would literally put down January 1st and what 2016 minus, let's say, 37 years, and we'd figure out what that year was. So we are supposed to help them estimate. If they don't know what the height is, guess. Make a good guess. If they don't know what their eye color is or weight is, make a good guess. But they do have to put some sort of description down because this helps the police to identify the other party. An address. This section is about providing an address for the restrained person. In the boxes that I marked off that they actually live together. So the program pre-filled the address in for me. If the parties do not live together and the restrained person does not have an address for the other party, they do not have to put something in. They can just put down unknown, and the program tells you that if you don't know, write unknown. The only thing that matters is that the petitioner will have to at some point have the restraining order personally handed to the other party. So an address would matter at that point, but for our purposes, even if they do not know where the other party lives, we can move on and help them with the restraining order. Now, this is the section for the minor children that both parties have together. Your children with a restrained person. We start off with the oldest child, and then go from there to the second child, third, fourth, and you go on, so forth. And it's the name, the date of birth, as well as the gender, okay? Then it asks, do you want your restraining order to protect your children? Most of the time, it will be yes. Sometimes parents will tell you, I don't want my children protected because I want the other parent to have visitation. What they don't understand is that they can have visitation as well as protection. This means that even if the children are protected from the father or mother, they can still have visitation with their parent, and the protection only applies to outside of those times of visitation. If there's an open children's court case, which remember, that court will have exclusive jurisdiction over the minor children in regards to child custody, visitation, and protection. That may complicate things. So while we can still help the petitioner request the custody protection orders, so on and so forth, the court, in fact, the family law court might not feel comfortable making those orders. And it is our duty to inform, and it is up to the petitioner to decide if they're going to move forward with protection / custody visitation, or go back to children's court and have that judge make those orders. The next screen then says, please check to make sure this information is correct. Now, because this is the PowerPoint and these are captures of each of the questions, you won't get to see this, but this question right here where it says, is this information all correct? It's one of those red questions, which basically means that unless you mark off an answer to this section, you wouldn't be able to move forward with the interview. In this case, you're going to literally turn your computer screen to the litigant and have the litigant look and see if all the information, names, addresses, the children's ages, and their names, as well as the physical description of the respondent, if all of that is correct. And only once they see that it is correct can you then mark off yes and move forward. And one thing that I forgot to talk about is just initially when you're starting out, it will take you a long while to get through an interview. Now, the program sometimes will have problems where because it's been so long, it'll sign you out, but it will sign you out without giving you any kind of warning. So it's on you to make sure that there's a little floppy disk icon up right here on the upper right, and you want to make sure that you are saving as you go along, because when you hit save, you'll be able to save the interview up until that point and then go back so that you can go back to the questions. And you want to do that at least every 5 questions, I would say, in the beginning. The next question then asks, did a social worker tell you to come? So DCFS is Department of Children and Family Services, Child Protective Services in LA County. Did a social worker tell you to come and get this restraining order? And sometimes that'll happen because the litigant tells us they were told to get a restraining order just so that the social worker can close out the case. Now, we at DASH, we can help someone get a restraining order if there is a basis for the restraining order. Now, if it turns out that there is no basis for the restraining order, then there is nothing we can do, and we can only tell them that they have to go and talk to the the social worker and explain that there is no abuse. We actually have a letter to the agency that we can help them. It's like a fill-in-the-blank template that we can help them fill out that basically says if there's no abuse, then we can't help them. If a litigant feels like that they're being forced to do this and they really don't want to do a restraining order, we also have another option on that letter that says that the social worker cannot force someone to do a restraining order. You cannot use a threat of removing a child from the home in order to make a parent get a restraining order. So we can also help the litigant take that letter to the social worker. The only thing is they cannot threaten to take the child, but they can remove a child from a home that they believe is dangerous for the child. So most of the times, if there is physical violence, the parent who's come in will end up moving forward with the restraining order. and that's what we're there for. We can help them do the restraining order. And then if they come back a month, 2 months later because the danger has passed, the case with DCFS is closed, we can then help them to apply for a termination of the restraining order as well. And from that point on, it is, and once you give the options to the petitioner who's there, the parent that's there that day, it is up to them to decide if they're going to move forward with the restraining order and comply with what's required, or not move forward with the restraining order and advocate for themselves. And because we're self-help, our hands are tied in terms of how much we can speak with anybody on the petitioner's behalf. Now, if you mark off yes on the program, it says that yes, the social worker did tell me to come here and get a restraining order. The next question is there an open case in children's courts? And if you mark off yes, the program will then tell you can't move forward with this restraining order, which is really an incomplete answer. Because what happens is that if there's a children's court case, the family law court might be hesitant to make any orders, but if there is an emergency situation, if there is a chance of great harm to the minor children, then the court will make that order. So it really is up to the judicial officer, and we should not be telling litigants that they cannot ask for these orders. We should tell them that the court might say no. So in this case, we marked off no, but as you can see that there is a field that says provide the name, location, and phone number of the social worker that told you to come here and get this restraining order. Because if the judge has any issue with the restraining order petition, they might even call up the social worker and say, what are you doing? This was an improper referral. So that gives the judge the option of, contacting the social worker if they need to in this kind of situation. So procedural issues, are there any other court cases? This is to get to if there are any other conflicts in terms of jurisdiction. So can the family law court make any orders? If we mark off Monterey, if you mark off children's court, as you can see right there, it says juvenile. Juvenile means children's court. So if we mark that off, then the court will know that they might have to they might not be able to make the orders they want to for the children. If we mark off divorce, then the court will know that the hearing for this restraining order is going to be in the courtroom in front of the judge where the divorce case has been filed. If we mark off guardianship, that means that there might be children in this case who are in the care of maybe grandparents or whatever other cases there might be, because guardianship is basically about someone who's not the biological parent becoming the custodian, the guardian of the minor child. And then it asks, do you have an attorney representing you? So if you remember in part 1 of this training, I did say that when you're screening someone, you want to ask them up front if they have an attorney. Now this is where the program asks about the attorney. It's, as you can see, more than, it's about 10 screens down, definitely more than 10 screens down. And you might have already spent half an hour to 45 minutes just getting the initial stuff out of the way. And if the litigant at this point says, yes, I have an attorney, yes, I have an attorney in my divorce case, we have to stop and we have to end the interview. So it's better to get that question out of the way first, because that way we can then tell them immediately we cannot help them or that we can help them. Do you want to file this restraining order in your divorce case? So if the litigant has their case number, and depending on what court you're filing in, if the litigant has their case number, we can mark off, yes, I want to file this in my divorce case, because that's usually what will happen. The court will end up using the divorce case number as the case number for the restraining order as well. Imagine it this way, that the divorce case is the umbrella, and the domestic violence restraining order case will come under that umbrella as part of that family law case. Now, if the litigant does not know the case number of their divorce case or their paternity case, because that's also family law, we can then mark off no and move on. Is there a restraining order or protective order in place that protects you or the minor children? This is where we would mark off if there are any other protective orders in place. And what that does is that it then kind of reminds us, the program reminds us, attach a copy of the restraining order or protective order if you have one. So one, that it will remind you guys to attach a copy of the EPO or the CPO. Now, if the litigant tells you that there's actually a domestic violence restraining order, you have to stop and think. If there's already a domestic violence restraining order in place, why are we helping someone do another domestic violence restraining order? So that's going to stop you in your tracks, and you're going to come to the backup attorney for more questions, because you would then have to ask the litigant more questions as well. Is there a custody or visitation order in place for your children with John Andrew Smith? And in this case, obviously, yes, there might be from family law, a previous domestic violence case where the restraining order might have expired, a guardianship case. So there can be other kinds of, all those cases can get you some sort of custody and visitation orders. And if you mark off yes, it'll ask you for a case number. At some point, it's going to ask you what those previous orders are. And then if you notice the little blue arrow on the right there that's pointing at the save icon, so you, like I said, you'd be saving probably every 5 questions. And then this next question is one of those very complicated requirements in the sense that it becomes very hard to explain to the litigants what they have to do. But it asks, the program asks, have you told John Andrew Smith, which is our fictional RP, that you are getting a restraining order? And it asks, have you told him that you're coming in at this location on this date at this time to ask for a restraining order? And if you say no, the program then, well, you know, let's go off, we'll start off with the yes part. So if you say yes, the program will then tell you specifically that you have to tell them specifically as to location, department, date, time, and what orders you will be asking for to be able to provide sufficient notice. And you can see we have an example of what needs to be said. And then we have a red question. Did you follow all the rules for telling him that you did this? And then you could mark off yes. And what's going to happen is, let's go back to this screen. What's going to then happen is that you can then fill out when you give them the notice, and the requirement is that you have to provide notice before 10 a.m. the court day before. That means that if I want to go in on Monday morning to get my restraining order, I would have to provide notice to the other side by 10 a.m. on Friday morning. And it would be specific as stated, and it would basically then mean that I could go in, I could put that time down, that date down, and the form that you have to fill out then asks, how did you inform them? And then under penalty of perjury, the litigant signs and says that I did this. And so that is if the litigant says that I have provided notice, because the court gives them that warning about what you have to do to provide notice. And this is before the litigant can even file their temporary restraining order. Now, if we go back to this screen and the question, and the answer is no, I did not provide notice, the program then asks you, are you afraid to tell the other party in advance that you're going to come and get this restraining order? Because that means that there's going to be a 24-hour window, or a 24 plus hour window where they could do whatever they want against you. If you have that fear, there's an option. But in this case, if we mark off where the program then tells you that you have to inform the other party, and then you have to give them notice before a certain time by telephone or in person, and then you can go in and file your temporary restraining order. If you say yes, you are afraid, the program then asks you, what are you afraid of? And we can mark off that I'm afraid that the violence would reoccur. I'm afraid that the other party would take the children out of the area, or for some other reason. And that means one thing you have to be aware of, if you mark off, I'm afraid that the violence is going to reoccur, be very clear that we then have to provide details to the court about what violence occurred in the past. If there has been no violence, we cannot mark off reoccur, because there has been no violence in the past. We can mark off I have another reason. If we mark off I have another reason, it'll give you a field down here where we can put down in detail what the fear is. I'm afraid that the other party is going to follow through on their threats and actually physically harm me. I'm afraid that the harassment and stalking is going to escalate. So we can put those things in there. We can have another reason, could be the other party is currently incarcerated and I have no way of contacting them. So it doesn't have to be that there was actual previous violence. It could be fear of future violence. It could be the second option is I was afraid that the other party would take the children out of the area. It could be that as well. So basically, we want to tell the court why the petitioner should not be forced to give notice. Now, this is where we come to the personal conduct orders. These are orders which, as we talked about in part 1, this is about RP not harassing, attacking, striking, threatening, assaulting, sexually or otherwise, hitting, following, striking, molesting, destroying personal property, keeping under surveillance, blocking their movement, or disturbing the peace. Very, very general. It can be also, personal conduct orders are also, do you want to ask the court to order no contact, direct or indirect, which means, of course, directly by them, but also through third parties. Now, you'll have some parties who'll say, or parents of parents who have children together, or even elderly parents who are getting it against their children, they'll say, I'm okay with contact because I want my son to be able to contact me, or because we need to talk about the children. You can tell them the court will make exceptions for brief and peaceful contact regarding any minor children. You can tell them a restraining order is only as good as how much you enforce it. So if he contacts you, if your daughter or your son contacts you, and they are behaving normally, you do not have to report them to the police. The issue is that if they don't mark it down right now, and then the other party starts using that way of contact as as a way to harass them, then the problem is going to be then they're going to have to come back and modify their restraining order, and we do not help with modifications of restraining orders. So you do have to give them that spiel that, well, we understand that they do want they're okay with contact, but if that becomes the only way that the RP can get to them, well, what if the RP starts abusing that avenue in order to abuse them? And from there, it is up to the litigant to decide what they want to do. These are the stay-away orders. Once again, we have the little arrow right here telling you to save as you go along. And in this section, you want to ask the litigant, what places do you want them to stay away from, the other party to stay away from? The individual themselves, and then any people they listed are all automatically marked off as that the other party does have to stay away from them. Now, the program defaults to 100 yards, which I said is the length of a football field. And realistically, you will have litigants who'll say they want it to be 200 yards, 400 yards, 1,000 yards, and you have to let them know that the default, which the court will then most often chooses, is 100 yards, and the other party has to be able to see you to avoid you. So if it's 1,000 yards, if it's 200, 300 yards, would they even be able to see you and know that they cannot be at a specific location because you're 200 yards away? But once again, we're self-help, so if you tell them that that is what the default is, and if they want to raise that, then they raise that. We then mark off all of the locations they want protected: home, there are things, for example, a vehicle, job, children's school if they have children together, or child care. If someone tells you, I don't have a job right now, I don't drive, I don't have a car, you do want to go that extra step and ask them, well, do you think you'll have a vehicle? Do you think you'll have a job in the next 5 years? Because if they say yes, we do want to mark it off. Why? Once again, because we want to front load everything, because if they have to come back and modify, they will have to do it on their own, because the dash clinic does not help with modifications of restraining orders. Another thing is they can also mark off another place, and they can provide additional places, for example, like a church, my sister's home, my high school, whatever, and they would then have to put down the address. You do want to make sure, though, that the other party, the RP, already knows what that address is, because if they put down my best friend's home and they put down an address that the RP does not know, well, the RP will know it once they see the paperwork. So every time, and you want to start off the interview with this as well. You want to let the litigant know everything they tell you, the other party will see. And then at this section, I'm going to ask you to ask them again, does the other party already know where your church is? where your best friend lives. So do ask that question once more. The program then asks, if you ask for these stay-away orders, will the other party be able to get to their home, their job, their school, etc.? In our situation, we picked that the two parties live together, so we would mark off no, and then the program asks you for an explanation. And it can be as minimal as RP currently lives with me, but I'm requesting a move-out order. Or RP and I work in the same office building. Or RP and I go to the same university. So we can put that explanation down, and the next section then asks you, do you want to ask for a move-out order? In this situation, because they are living together, we can ask the court to make a move-out order, and the program will ask you, well, what right do you have to live on the property? What is your claim to the property? It can be as simple as, I have lived there with our children for the last 4 years. I have nowhere else to go. It could be, I'm on the lease and I pay for part of the rent. It could be, I've been living there for the past 4 years and I've paid all the utilities. So we can ask the court to at least make temporary orders, and then from there, hopefully we can make that move-out order permanent as well. Do you want to ask the court to make an order that John Andrew Smith, so our RP, must go to a 52-week battery intervention program? As mentioned in section 1, in part 1 or 2, that these are weekly classes that are year-long that the RP is on the hook for paying for. They would have to attend these classes and learn about domestic abuse, how not to be abusive. Whether they're really helpful or not, really, that is up in the air, but a petitioner can ask that RP be ordered to attend those classes. Some petitioners will tell you, I don't care, I just want this person out of my life. Some might say, you know what, he's going to have to pay for it. I want that because I want him to be punished for what he's done. Either way, it really is up to the judge, but the litigant will decide if they want to request the attendance in this program or not. The date of the most recent abuse. So this sample has 2012, but basically we do want to put down the most recent incident of abuse, and abuse, remember, is a very broad definition. So when was the last time the other party did something to make you afraid? That might be a better way of handling it, a better way of asking it. It could be physical, verbal, harassment, stalking, a phone call. It could be anything like that. And then we tell the court what happened. Was the police called? Did you get an EPO? Things like that. And who else was there? The program then gives you a field to detail what the abuse was. And in this case, it's going to be about an incident that happened on 118. And the program tells you, use RP for the other person. And then that example that it gives you, it has the first person view in it. So it should be from your point of view. RP came home drunk. I could smell the alcohol on his breath. RP started arguing with me. He punched me in my stomach and on my face 2 times, once near my right eye and another time on my mouth. So basically, it's going into very specific detail of what happened. It's from the point of view of our petitioner and refers to the other party as RP. So in this box, you can fill out the initial details of the abuse. And it really does depend on preference. You can either put the details here, or later on when you open up a Microsoft Word document, you can put the details there. Either one, it is your choice, but I would suggest whatever you pick, you do save once you're done typing in the details, because you do want this screen at least to save. The next screen then asks for the date of the second most recent incident of abuse. Same thing. What was the second most recent time that the other party did something to make you afraid? What did they do? What happened? Who was there? And then from there, you're going to go on to another screen that asks you, what did the other party do? Use RP for the restrained person, which means don't use their name. And once again, it's from the first person view. So these are the initial details of the abuse, and you're going to work with these and flesh them out later on in a Microsoft Word document. You can choose to skip these screens because you can do all of the typing in the Microsoft Word document if you so prefer. And so from here, we're going to end part 3. And this is, once again, the DV Hot Docs program for DASH, and this is the end of part 3.